on the record. Today is June 7th of the year Lord 2021, and we are making this video. This court is now open and on session under Title 28, Section 636, Subchapter Golf, and under Rule 203, Court Martial Rule 203, Jurisdiction over the offense. In this video, we're going to start a little bit ahead of time. We are expecting to make a phone call to the 13th Judicial District Court on Valencia County, New Mexico. This court has kidnapped an honorable member of the Military Welfare Service. For the Honorable Jesús-Arriaga went to court 5 times, and the 5 times he invoked he reserved his rights. He invoked the Fifth Amendment or plead the Fifth Amendment. The question continued, and this is evidence that 5 times, 6 times, and today, hereby, all rights are reserved under the Universal Commercial Code or the Uniform Commercial Code 1-308, 1 UCC 1-103.6 and UCC 1-109. In a brief description of what is going on, the 13th Judicial District Court for the 13th Judicial District Court for the District of New Mexico has filed a foreclosure. They've been caught. This foreclosure is bogus. They never exist. The bank have withdrawn, and for the Honorable Jesús-Arriaga went to file a document on the court of probate. But first, he requested the aid of the Sheriff's Department. It turned out to be the Sheriff's Department is the one that went over and kidnapped a federal postal judge, sui juris, and one other people. Now, we're going to start this video here with a short video in regard to protective rights. In regard to, we had to go and find some judges out there to come and tell you guys, you don't know what you're doing. And if you pay attention to this, you will hear from them directly. So please stand by.
This concept of separation of powers is what makes America great. It is absolutely the genius of our democracy.
Here we are over 2 centuries later, and still the Constitution with its 3 pillars of government exists in the same form as it did at the founding.
All of these parts working together creates a team effort, which really aids our form of government and creates its stability.
This is real-time video. This is bound to happen, and you have to realize that. Or maybe I have to play this 3 times for you to know and realize. I hope you speak the language.
concept of separation of powers is what makes America great. It is absolutely the genius of our democracy.
Here we are over 2 centuries later, and still the Constitution with its 3 pillars of government exists in the same form as it did at the founding.
All of these parts working together creates a team effort, which really aids our form of government and creates its stability.
Many people don't realize that the Constitution sets out 3 branches of government. The first is the legislative branch. The second branch is the executive branch. Now, we typically think of the president, but it also includes all of his executive officers. And the third is the judicial branch, and that means the Supreme Court, but it also means the United States Courts of Appeals and the United States District Courts.
Why would the framers want to set up such a complicated system that consisted of 3 branches of government with separate powers but with some codependent powers?
They were students of human psychology.
Because they appreciated that a free society does require the fusion of authority.
They said the right way to do this is to have checks and balances.
Each branch has designated powers, but some of those powers are codependent on cooperation with the other branches of government.
The process of passing a bill in the Congress requires a lot of debate and discussion and compromise.
Congress, they can't act alone to create a law. It requires the president to approve the law. Of course, there's the veto power.
If he vetoes it, it goes back to the Congress, and if they truly believe that the law should be passed, they can override that veto by a 2/3 vote.
Those laws are further held in check by the judicial review process to make sure that the law complies with our Constitution.
If someone doesn't like that law, they can challenge it and argue that it violates the Constitution, and they can file a lawsuit in federal court. And if that happens, it's up to the judicial branch to decide whether the law complies with the Constitution or not.
The judiciary is likewise checked by the other branches. Number one, it has no policy role in the government. It simply interprets the law. And so if a particular judge or circuit judges or the Supreme Court justices disagree with public policy, they have no say in that. They simply interpret the laws that come before them.
And if Congress passes a law that's challenged under the Constitution, the judiciary has the power to say that law violates the Constitution and to strike it down. But that's not the end of the story.
Congress can come back and look for another way to try and achieve the same result in a fashion that is constitutional, and they've done that on many occasions in our history. We've got Congress and the president, and they're elected.
The president nominates us, and then the Senate confirms us. But the reason for that is so that we can retain our independence.
The founders felt that the independence of the judiciary was critical, and one of the crucial ways we have that independence is through life tenure.
And we don't have to answer to Congress or to the White House or to the executive branch if we make a decision they disagree with.
When there is a decision from the Supreme Court that's not popular, sometimes that lack of popularity is exactly the way the system is supposed to be working. The example I'll give you there is flag desecration.
There was legislation that precluded the burning of a flag. Obviously, the executive branch sought to enforce that legislation, and then it ultimately became the responsibility of the courts to make an assessment as to whether that legislation was constitutional.
No one's in favor of burning a flag, but the idea is that the Supreme Court believes that the Constitution protects everyone's liberties, even for speech you don't like.
And that's what the First Amendment is about, and it's through the separation of powers that we're able to protect that.
The courts are the ultimate guardians of the law. We don't have the power of the purse. We don't have an army. Our only power is our ability to defend the Constitution.
What the federal judiciary has is, as the guardian of the Constitution, is we have the last word on what the Constitution means.
The reason we endure is because we have a system that ensures through these 3 separate branches of government that check and balance each other all the time, that all of us are protected by a single system that seeks to ensure fairness, liberty, and justice for everyone.
Any questions? If you say yes, you are incompetent. If you say no, well, I hope you got it by now. Justice for all. You heard it from them. Now, you're not going to believe these judges, and they also say that if the Constitution is not enforced, a lawsuit is going to be filed in federal, right? Well, for the Honorable Jesús-Arriaga Abonce has filed a lawsuit on federal, and it's not a lawsuit, it's a common law cause. And under the Universal Commercial Code 1-103.6, the code cannot be read. Judge, know it. Know it, the code cannot be read to preclude a common law action. If you violate the UCC, well, you cannot enforce the UCC, period. Are you going to enforce the UCC? You're going to have to start by honoring the Universal Commercial Code or the Uniform Commercial Code 1-308. Now, if you want to perceive this for the Honorable J. Jesús-Arriaga Abonce as an agent, an executor, appointed executor of the all capital name, well, for the Honorable J. Jesús-Arriaga Abonce is protected on the Uniform Commercial Code 3-402. In September 1st of the year 2020, for the Honorable J. Jesús-Arriaga Abonce requested the contract. You have no contract. The contract has not been furnished. And if you have no contract, well, you cannot perform contract law. Everything is contract law. Because the law is in the contract. If you cannot have a contract, well, then you don't have any law. And if you don't have the law, then you don't have jurisdiction. That's simple. Now, Cindy M. Mercer, you've been disbarred. John Durran, you've been disbarred. Brendan McDonald, you've been disbarred by the association, by the State Bar Association. On September 1st of the year 2020. This is 2021, and it's June. You haven't not provided the contract. You did not take your certificate of authority to federal court. You're in violation of 6 CFR 37.3, 1 Stat 23, page 1, section 1, and you're in violation of Title 4, section 101. And it is on the record. Now, for the Honorable J. Jesús-Arriaga Abonce and for the Honorable Adelina Arriaga Pedrosa, they do not speak the language. The commercial language is a fictitious language, and if you're going to proceed, well, Judge Clarence Thomas in the Superior Court for the United States clearly state that the process has to be conducted in a language that all parties agree. Now, would it be fair for me to start speaking in a different language? Bueno, vamos a ver. Usted no entiende mi idioma, yo no entiendo su idioma. F es kefe, yo fonofo, tefen, tefen, nofo, defe, kefe, mefe, afa, blafas. Si fi mefe, bafa, safa, tefe, nefer, afa, kifi, kofo, nufun, huifi, siofo, afa, pofo, clifi, kofo, afa, blafa, mefe, enfentufu, ifi, diofo, mafa. Now, for the Honorable J. Jesús-Arriaga Abonce requested the language that he understands, Nahuatl. And the doctor could not perform because the doctor, John Gatlin, did not speak the language. When the Honorable J. Jesús-Arriaga Abonce requested for the Nahuatl language, the answer, is this on speaker? It requested the answer of the doctor. Now let me see. The doctor's reply was clearly, I am not sure I understand what that is. Now, is it fair that a doctor is going to perform and then put a report on a language that for the Honorable does not speak? Well, that's unconstitutional. Now, is this here on speaker? Well, I would like for it to be on speaker. Okay. We are here with this terrorists who have no license to practice law in Mexico, who don't have the an oath that satisfies the 6th article of the Constitution. Do not speak my language. There is no bond, no foreclosure bond, no replevin bond, no performance bond, and you are all hereby precluded to participate in this hearing. Everything you say is hereby refused, rejected. Now, let me ask you something. Would you agree that corporate law is self-defining? If you answer yes, well, you are correct. For the Honorable J. Jesús-Arriaga Once is not a corporation. Please hereby accept that the non-corporate existence statement, denial of corporate existence. Now you're gonna have to prove that for the Honorable J. Jesús-Arriaga Once is a corporation. You're applying non-corporate law to one of the people, well, it's on the record. And your insurance is watching. We are here waiting to see you are the first one here. Share this meeting link with others you want in the meeting. Well, we could do this, but we touch this phone, we touch one button and the whole thing is out of screen. This is unfair. This is unfair. Now, when the doctor says, I'm not sure I understand what that is, understand is a verb. Doctor did not perceive the intent, meaning of the words, a language or a speaker. He didn't understand a word. That for the Honorable J. Jesús-Arriaga Once said, interpret or view something on a particular way. And look, please refer to the video on the minute 3937, doctor acknowledgement saying, okay, I think we are wasting our time. And yeah, you're wasting your time. Si yo te digo que no te entiendo y tú no me entiendes y yo no te entiendo, yo te voy a hablar español, yo te voy a hablar en mi idioma. Yo te voy a hablar en mi idioma y te voy a decir que pues lo que es. Ahora, si necesito un translator or necesito, it was very clear that it had to be in my language. Now, 30 days have passed. I believe it's over 30 days, and no arrangements have been made. And that's forensic evidence that that's forensic evidence that there is a discrimination, linguistic discrimination, and it's on the record. If you know that it has to be in a language that all parties understand, and you proceed indifferent, and then it's on the record. We're gonna take some time over here while we are still trying to connect with this terrorist, Cindy M. Mercer. John Durran, you are here fired. John Durran, you are here fired, sir, for the record. You've never been hired, you don't have a contract, and you cannot perform. You are here being charged with the death penalty by electrocution for criminal trespassing of a case, and your insurance is watching. Brendan McDonald, you are on the same charge of death by electrocution, and it's just a matter of time before it's enforced now. John Paul Johnson is my witness on this video, and he has been invited to overlook on this in regard to AUSC violation of due process. However, we are still trying. This is ridiculous that you schedule, that you are making an attempt to call when you know that I don't speak the commercial language. Now, let's go clear on this, okay? The commercial language is a fictitious language. Corporations are fictitious entities, and the name of the Honorable and for the Honorable J. Jesús-Arriaga Once is not being used on this video. Let the record show that there is evidence that they are using a bogus, fabricated name, which is Jesús-Arriaga on capital name, capital letters. Now, for the Honorable J. Jesús-Arriaga Ponce is an honorable member of the National American Red Cross and the Military Welfare Service. You think you can prosecute someone who is protected by the Geneva Conventions 4 of 1949 and Protocol 1 of 1977? Well, it's on the record. This video is going to be forwarded to the National American Red Cross and the International Committee on Geneva. And this is a warning. We are still trying to connect. This is ridiculous. I have forensic evidence that I have never been in contact. I have never received a document, so there is no service of process, and therefore this is illegal. This is unconstitutional. I have received a email from John Durran and Brendan McDonald. It's on the record, where they claim that I have court, but I is the equivalent of the imaginary quantity of the square root of -1, if you look for it on the dictionary. Okay. Now let's go over here, and we're gonna continue with this. Emure and those or confine someone against their will is kidnapping. PRO means no, no means no, un means no, referring to a specific thing previously mentioned or understood. Okay? Now, Dr. John Gottlieb, you were warned on the record, sir, not to write any reports in any language or fictitious language that for the Honorable J. Jesús-Arriaga Ponce do not understand. If you do so, or if you did, this is forensic evidence that you have violated and discriminated. You have violated for the Honorable J. Jesús-Arriaga Ponce's rights, protective rights, which he has reserved. You have proceeded when you know that this is unconstitutional in case you did proceed. The report is invalid, Cindy Mercer. This report is not written in a language that for the Honorable J. Jesús-Arriaga Ponce understand, and is hereby rejected because of lack of knowledge. Now, for the consequent knowledge, for the knowledge of the consequent facts is hereby with the request of the contract. If there is no contract, when did the Honorable J. Jesús-Arriaga Ponce engaged in a contract with the 13th Judicial District Court? Never. Do you have a signed paper? No. Did he sign? No. Did you give him papers of booking? No. He was kidnapped for 18 days. He nearly died. 18 days on hunger strike. Cindy Mercer, you are hereby charged with attempted murder. Attempted murder, that it is on the record for the Honorable J. Jesús-Arriaga Ponce, was taken by ambulance from the Valencia Detention Center. The Valencia Detention CDC is Valencia Detention Center, where he was held against his will with no crime committed. We are experiencing the same kind of problems with the communication. I have someone here making an effort to connect, and let this be on the record. It is ridiculous that you don't know when to stop. But hey, it's on the record. You have insurance, don't you? So now you're going to be charged, or you're hereby charged with malicious prosecution and violation of the UCC 1-308. Did you violate the UCC 1-308? It's on the record. You are going to go to Guantanamo, and you are compelled. For the Chief Justice on the corporate United States District Court for the Corporate District of New Mexico, you are hereby compelled to act up in a ministerial duty on the witnessing of a constitutional wrong, or be compelled to the same constitutional wrong by failure to act up on it. And it's on the record. You are hereby being compelled to act up in a ministerial duty and the witnessing of a constitutional wrong. John Paul Johnson, I adopt your oath, I accept your oath, bind you to it, remind you of a fiduciary duty, and extend immunity while you carry our orders in this Superior Court of Record, open under Title 28. Under Title 28, Section 636, Subchapter Gulf. Again, Chief Justice John Paul Johnson, I accept your oath, bind you to it, extend our sovereign immunity while you carry our orders. Now you heard this from from the judges that we have introduced here on this video. No unalienable rights shall be disrespected or overlooked. Dr. John Gatlin, you are using I dialect is the use of deliberately non-standard spelling to emphasize how a word is being pronounced. PRO means no, no means no, un means no, okay? CED, Charlie Echo Delta, is a section of the economy. However, I dialect is also common use to indicate that a character speech is vernacular, non-standard, foreign, or uneducated. And here it is, foreign and uneducated. So you're not educated on the language. How can you be educated in regard to anyone's cast of mind? It's on the record. You were not allowed, you were not given consent for treatment, and you were told not to write any documents, especially in a language that for the Honorable Jesús-Arriaga Once do not understand. I, the word you say, I, is the imaginary quantity equal to the square root of -1. And then you say M. The letter M is a prefix, a spelling of in, one, in, two, no, 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 assimilated before BMP as an imbibe, immure, and an immure, endorser, endose or confine someone against their will. Now, doctor, you agree that corporate law is self-defining, and you are a corporation, and therefore you have no authority to interact with one of the people. One of the people who wrote the Constitution and is an honorable member of the Military Welfare Service. Elements. I is iodine, is a noun. No means no, un means no. Pharmaceutic is a solution of iodine in alcohol used as a mild antiseptic. Is no. Doctor's acknowledgement to be using vulgar language. Vernacular equals vulgar. Known means no equals no. Un means no. And is vernacular language, vulgar language for the Honorable Jesús-Arriaga Once does not understand vernacular vulgar language for the record, on the record, to be read for the record. Now, John Durran and Brendan McDonald, you receive the Superior Court of Record motion on April 3rd, where you stated that it was fairly incomprehensible. Okay, in means no, intelligible. In means no, able to understood, comprehensible, understandable, easy to understand, or accessible. So pursuant the statement of the lawyer, whose name is not on the record, he declared, deposed, and affirmed verbally to have received the Superior Court of Record's motion to terminate and fire an impostor without a contract, criminal trespassing on the case. The lawyers John Durran and Brendan McDonald are trespassing on this case criminally, and the lawyers acknowledge is on the record. Minute 1837 of the meeting on May 3rd. Minute 1837 of 1 hour and 6 minutes and 45. Quote, the motion was fairly incomprehensible. So we have a lawyer here saying that the motion, that the Superior Court of Record motion, the Superior Court of Record's motion was fairly incomprehensible. Unquote, I didn't understand it at all. Now, for the Honorable J. Jesús-Arriaga Abonce, have forensic evidence that the motion was not digestible, understandable, easy to understand, accessible, user-friendly, lucid, clear, crystal clear, coherent, transparent, plain, simple, perspicuous, explicit, precise, unambiguous, self-explanatory, and penetrable. In short, the doctor said it. Unintelligible. Okay. Un means no. In means no. Tell is to tell. So not to tell. The lawyer said, I didn't understand it at all. I assume that a copy was sent to the court as well, but I can provide it to everybody. I don't know if that will be very helpful, but I think awaiting Dr. Gatlin's report will be the best manner in which to proceed accordingly. Now, Judge, we have forensic evidence that the doctor didn't interact with for the Honorable J. Jesús-Arriaga Abonce for the lack of knowledge and understanding. And we have the doctor on the record saying, I am not sure I understand what that is. If you accept his report, you will be in violation. For the Honorable J. Jesús-Arriaga Abonce speaks Nahuatl. Is an indígena, tribal governor Nahuatl, a special master in common law, culto, erudito, instruito, sapiente, and one of the people. Federal postal judge, sui juris, presiding in this Superior Court of Record, case number 1, column 20, dash, Charlie, Victor, dash, 00113, Kilo, Golf, space, Juliet, uppercase, Hotel Romeo, uppercase. Okay. And now we're going to go and place this for the record. And this is something written in regard to the language. Do you understand? Well, this up here is a scripta continua. And this is exactly how the process shall be presented. Now, for the Honorable J. Jesús-Arriaga Abonce demands trial by court-martial if he must come and prove his innocence. But we have submitted a video where the Sheriff Department kidnapped for the Honorable J. Jesús-Arriaga Abonce, and it is on the record. How can you kidnap somebody without a phone call? No phone call for the first 11 days, I believe, for the Honorable J. Jesús-Arriaga Ponce was demanding to make a phone call, and then his family called over there. And they say that they couldn't give him any information, so hey, I wasn't communicated. They wouldn't give any information. And the fact of the matter is that they requested cash ransom to release one of the people. Now, that's forensic evidence that they are detaining or arresting, kidnapping people in exchange for money. That's human trafficking. That's human trafficking. That is forensic evidence. And then when the family shows up there to pay, they have cash and they say, no, we want money order.
They are late.
And
The
when,
court is booked.
oh, okay, well, we just got notice that the court is late. The supermarket court is late. And while we get on this, we're gonna get into this, into a little bit of more detail in regard to this criminal activity. Cindy M. Mercer, it is criminal contempt of court to bring a process on the name of a fictitious entity or a non-existent or a bogus entity. Act up now in a ministerial duty or be compounded to it. You were informed that for the Honorable J. Jesús-Arriaga is one of the people, and people are not prosecutable by the judiciary. But if you can bring something into the record, we'll do so now. Now we're gonna take a minute to go and introduce this to the record. Okay. Cindy Mercer stated on September 1st that for the Honorable J. Jesús-Arriaga Ponce needed to wait to be acknowledged. It is June 7th and it hasn't been acknowledged. For the Honorable J. Jesús-Arriaga Ponce has not been acknowledged, and it's on the record. So if you proceed without acknowledging the right parties, well, you are at a loss, Cindy M. Mercer. You are a judge, don't you? You went to judge school. Did they tell you, yeah, you can proceed without acknowledging anybody? So you just walk in and you just do your thing and then walk out like you did that one day on September 1st of the year 2020. Now, Cindy, you said that it will be prohibiting, okay, prohibiting. PRO means no. PRO means no. Hereby. On Japanese is day to day. In Spanish is día a día. ING or NG in Filipino, de por y con, or of, by, with. This is what ING means. I or NG. NG means de, por y con, of, by, with. If the sentence starts with a negative, the entire sentence is a negative. Now, this is a foreclosure case in which the bank, you read second grade English, correct? Disclosure statement. In this disclosure statement, you might want to take your screenshot, but you have this document, disclosure statement. And this is dated on a loan date on March 2nd of 2009. March 2nd, 2009. We're going to go over here to this document, page 2. Of the mortgage. This is the mortgage, which by the way is bogus because it was never recorded. So if it's not recorded, it's not enforceable. And we go here to page 2. In page 2, warranty defense of title, the following provisions relating to the ownership of the property are a part of this mortgage. Title, grantor warrants that a grantor holds a marketable title or record to the property and fee simple, you know the term, fee simple? Fee simple. Here is where my finger is, fee simple. If the Honorable J. Jesús-Arriaga Bonsan for the Honorable Adelina Arriaga Pedrosa own this property, fee simple, well, you've been busted. How did you obtain your foreclosure rights? Let the record show that for the Honorable J. Jesús-Arriaga Bonsan and for the Honorable Adelina Arriaga Pedrosa is one of the people, and they hold title on the property. Fee simple. Not much left to do in your process, right? So if we have a document that by the court is acknowledging that they are the owners, then the other party doesn't have any documents, and they are bogus, and this is bogus, and this is a terrorist act, and they are acting against the law, and you're supposed to enforce the law. Judge Cindy Mercer, you're not a judge. You are not a judge for Cindy Mercer. M. Mercer, you are not a judge. I don't believe you are a judge. Neither John Paul Johnson believes that you are a judge. He does not believe because in legal matters, then the legal name has to be used, and that is not your legal name. Now, the process has to be on the name of the people of the state of New Mexico, and it must have a seal of the court that issues this process. There is not even a service. You don't have certificate of service. The process has never been served, and therefore it cannot proceed. So on September 1st, Cindy M. Mercer, you are on the record saying that everything has to be compliant with the Civil Code of Procedure. And this is civil, right? So this is civil. Can you please direct the Superior Court of Record with the location with the location of the rules of criminal procedure for statutory jurisdiction? Please do so now. I'm going to say it again. Common law or statutory jurisdiction? Please furnish the rules of criminal procedure for statutory jurisdiction. Can you provide the location of a copy? Is this a civil criminal action? Civil criminal action? The public rules of court. Now, denial of proper warrant on the violation of Title 18 U.S. Code Section 3571 is $1,250,000. And then this is forensic evidence that there is not a grand jury indictment. because the grand jury indictment will become the warrant, and only then you can arrest anyone. But in this case, for the Honorable J. Jesús-Arriaga Abonce was assault, was assaulted, criminal assault by a detective whose name is not on the record because he uses two initials and then uses a last name. But on the video we have it, so you're gonna have to go watch that video of the real-time kidnapping by the sheriff department, and it's on the record. Violation of breach of contract. You have a contract where you will uphold the Constitution and protect the people. It is forensic evidence now on this record that you are in violation of breach of oath contract, in violation of Title 18 U.S. Code Section 3571. Each violation is $250,000 on lawful money minted by the United States Treasury. We are giving part to the state bank regulator. We are going to be directing all documentations to the Consumer Financial Protection Bureau, to Dave Warehill. And we're gonna put it here for the record. This is your name. Dave Warehill, Consumer Financial Protection Bureau. Now, Cindy M. Mercer, Title 28 U.S. Code Section 1746 speaks about unsworn declarations under penalty of perjury. Do you have a sworn statement by the detective who's pressing charges? No, you don't. Do you have a sworn statement by Dr. John Gatling, forensic psychologist? No, you don't. Now, doctor, please tell the world, tell this court, how is it that you can write an essay or a report in regard to a consultation or one of your practices if you never spoke to your to whoever it is that you pretend to be practicing with? Now, you don't practice. Practice is when you practice yo-yo. You practice a song. You don't practice with people now. They're gonna be practicing on you on Guantanamo, and you, Cindy Mercer, they're gonna be practicing on you on Guantanamo, and they're gonna be practicing the law because this is the way it has to be done by the record. John Paul Johnson, would you agree, sir? Esquire John Paul Johnson, would you agree that it is a violation of breach of contract on violation of Title 18 U.S. Code Section 3571 when anybody is detained and thrown in jail? Now, we're going to introduce another document, if I may, now that I have it here. Cindy M. Mercer, is that your name, your signature? Cindy M. Mercer, that's your signature. And it says over here, we're going to read this document for the record. Take your shot. And now this document here is on the 13th Judicial District Court, County of Valencia, State of New Mexico. And this is Bank of Albuquerque plaintiff. And it was filed on the 13th Judicial District Court on Valencia County on 17th of March of the year 2021 at 11:54 a.m. And Philip Romero, you are guilty of treason. You're accepting these documents by a judge that has been disbarred, and you are working on concert to violate the rights and to create jurisdiction against one of the people, so that is treason, sir. Case number Delta 1314-Charlie Victor 2019-01401 versus Jesús-Arriaga. Who is Jesús-Arriaga? In all legal matters, the legal name has to be used, and Jesús-Arriaga is not the legal name and is not a defendant. And you have here a social security number 03A12711. That is a bogus number, and it is false and misleading representation sent to the record in violation of Title 15, Section 1692E. Let the record show that this number could not be related with and for the Honorable J. Jesús-Arriaga Ponce, and neither this date of birth, which is 72959. To Valencia County Detention Center, and you wrote this document to Valencia County Detention Center. From the Honorable Cindy M. Mercer, and then is accept for custody on Wednesday, March 17, 2021. So you just go over there and say, hey, accept for custody. No charges. We don't have any charges on this document. No charges. If there was a charge of trespassing or a charge of violation of anything, this document here is totally bogus. Totally bogus. Laughable. Laughable. Now, this document has been endorsed here on the front, and by all means, this document should have been endorsed on the back. And this is the game that you play. You endorse it on the front, so when it's shown this way. Well, let the record show that this is the correct way of doing it. But on that very same day, for the Honorable J. Jesús-Arriaga Ponce had filed an executive order under Title 28, U.S. Code Section 636, Subchapter Gulf, Court Martial 203 jurisdiction over the offense to solicit Article 137 and the first article of the Constitution. Now, Cindy M. Mercer, you are compelled, and for the Honorable J. Jesús-Arriaga Ponce, hereby solicit Article 4, Section 1 of the Constitution, where you must surrender the process to the federal court, to the corporate United States District Court for the corporate district of New Mexico, and its validity. You are a judge, and let the record show that on this 7th day of June of the year Lord 2021, one Cindy M. Mercer, district judge, 13 Judicial District.
Case number D1314 SI 2021-28. You'll make your appearance for the record.
Objection. This is the wrong name. And for the Honorable J. Jesús-Arriaga Ponce does not speak the language. All rights are reserved. The lawyer has been fired. All rights are protected. Rights are protected by the Constitution. You can hear me. I can hear you. You're gonna speak, Brendan. You are fired. You are fired.
You need to stop talking until you're asked to speak, please. Thank you.
This is not Mr. Arriaga. If you call me Mr., I'll charge you with violation of sexual discrimination. Violation of Title 18, Section 641. You're not doing your job. You're in violation of 6 CFR 37.3.
All right. Go ahead and enter your appearance.
Brendan McDonald, I represent Jesús-Arriaga, who...
Absolutely now. Objection.
All right. And the court is familiar with Mr. Arriaga and will verify that he has appeared by video for today's hearing. I did ask Mr. Arriaga to not speak until he was asked to speak.
Don't speak the language. Don't speak the language. For the Honorable J. Jesús-Arriaga, don't speak your language.
You comply with that. So the court put him on mute. With regard to this matter, the court has set it for compensation. I know questions from Gatling. I believe both parties received a copy of that. Is that correct?
That's correct, John.
All right. So the state should
Treated to this is confident and substance. I haven't had a chance to speak with Dr. Gatling about that portion of it. Respectfully,
Mr. McDonald?
I'm in disagreement with that, simply because I believe that Dr. Gatling did make a finding, relate to Dr. Gatling's finding. I can't imagine he changed his finding. He's doing. However, if the state wishes to charge that year, this might be asking that competency be. We do believe we have a determination that he is incompetent. We would ask for a stipulation from the state in that regard under remand to magistrate court, consistent with that finding. Getting him there and having this done, and obviously having multiple hearings with this particular, be difficult with this particular defendant. I believe.
All right. Well, it does sound like Mr. Ward wishes to have some additional time to talk to Dr. Gatling. I cannot just accept a step out. Both sides being in agreement to have that determination made without a full evidentiary hearing with Dr. Gatling present. So I will go ahead and allow some additional time for Mr. Ward to discuss matters with Dr. Gatling. If it's determined that you need to help out, then the parties can submit a stipulated order to the findings of the forensic evaluation, and then the court can enter an order consistent with that finding. If not, then I will reset this matter for a competency hearing. And if you're going to expect that that will be a evidentiary hearing, you need to let the court know so we can allow enough time for an evidentiary hearing on Mr. Arriaga's evaluation.
The only other request I made just Dr. Gatling that I'm present for the conversations as well.
I couldn't hear you. Sorry. Go ahead. Say that again.
I would just ask that if Mr. Ward is going to have conversations with Dr. Gatling, that I'd be present for those conversations as well.
All right. So the parties can coordinate that phone call with Dr. Gatling and then determine what all right. I will go ahead. You and I'll notify the parties as to the date of reset by separate.
Pathetic. Pathetic. I bet you if I give you a copy of this video, you won't even know what was talked about. I mean, the conversation is in a fictitious language. It's hard to understand. For the Honorable J. Jesús-Arriaga, I won't say hereby pleads the fifth, invoke all amendments of the Constitution, and protect its protective rights to protect, reserves the right to protect its protective rights and the right to proceed accordingly against all trespassers. Now, Cindy M. Mercer, I'm going to read this document for the record. Brendan McDonald and John Durran, you received this document via email. You received this document via email, and it is on the record. It is on the record that you received this document, and I'm going to read it for the record. This is a maritime contract. For the Honorable J. Jesús-Arriaga Abonce of the Abonce family, P.O. Box 2441, Los Lunas, New Mexico, XXXXX99-98, all rights reserved under Uniform Commercial Code 1-308, 103.6, and 109. With the forgery of the given name is with the objection, with the infringement of the copyright. Affidavit of truth. The Superior Court of Record on its own motion. Lawful notification to all parties listed in Attachment 1. Reference your oath affirmation requires you to protect my right to defend my rights. This letter is lawful notification to you that you are corresponding with one of the people of this United States of America. As one of the people, I was endowed by my Creator with certain unalienable rights, one of those rights being the right to defend my rights. It is important that you know and understand that my Creator endowed rights are protected and guaranteed by the Constitution and the amendments specific to the Bill of Rights. You took an oath affirmation to support and defend the Constitution encompassing the amendments thereto. The United States Supreme Court has ruled that the state cannot diminish rights of the people. Hurtado versus California, 110. Uniform Sierra 516, where rights are secured by the Constitution are involved. There can be no rulemaking or legislation which will abrogate them. Miranda versus Arizona, 384 U.S. Uniform Sierra 436-491. Consider this your formal notification that all my rights must remain. All the rights for the Honorable J. Jesús-Arriaga Abonce must remain inviolate at all times. At no time I have given you delegation or authority to vote, to deprive me of a right, or even diminish one of my rights. Not only do I forbid, but the Constitution forbid. It does not specifically grant or vote on any issue that will ultimately diminish one of my rights will be a crime against me. Do you understand? A violation of your oath affirmation to support the Constitution and will be considered warring against the Constitution. Do you understand? No state legislator or executive or judicial officer can war against the Constitution about violating his solemn oath to support it. Copper versus Aaron, 358, United States, 118, 1958. Observing the many congressmen and women and senators will lead to one conclude they simply don't have a basic understanding on how their oath is their solemn binding commitment to support and to protect the people's Creator endowed rights. They just do not possess the authority to tamper with the people's Creator endowed rights, period. The oath actually forbids the oath taker, public servant, from attempting to deprive or diminish a right of the people. At the very least, you should be made aware that violation of this oath is felony perjury, insurrection, section on treason against the people. Believe it is also important for you to know and understand that I do not have constitutional rights. If the state and federal constitution and their respective bill declaration of rights were to vanish from the face of the earth tomorrow, we'll still have the rights I possess today. I can only be disposed of my rights if I am deprived of my ability to defend them that deprivation alone will be actionable under federal states known as Bivens actions and 18 U.S. Code Section 241 and 242. It is not for a government or any oath-taker public servant to determine for me what is permissible for me to acquire and possess in order to defend my rights to life, liberty, and the pursuit of happiness. By this letter, notification is given that I will be monitoring, maintaining a record, and evaluating any all communications and actions by all parties specific to this matter pursuant to my creator endowed rights, secure and guaranteed by the federal Constitution, and amendments specific to the Bill of Rights. Any oath-taker, public servant operating as a federal government that will vote or otherwise attempt to diminish one of my rights, including the right to defend all my rights by the modes, methods, and technology, advanced tools of the day will be determined to be a direct assault upon the infringement of my constitutionally guaranteed and secure creator endowed rights. Should any infringement of my guaranteed and secure rights occur on your part or by any other party with whom you claim affiliation, will scrutinize said infringements and any injury therefrom pursuant to federal statutes known as Bivens actions and Title 18 U.S. Code Sections 241 and 241. At a minimum, I will proceed accordingly. Do you understand? Should there be anything in this notice that you lack understanding or that needs clarification, please respond within 21 days. So 21 days from June 7, it's on the record. From June 7, 2020, the Superior Court is hereby set under the laws of the Republic. Open court under Title 28 U.S. Code Section 636. Silence is acquiescence, agreement, and dishonor. This is a self-executing contract and administrative remedy claim, treaties, and constitutional enforce. Provide certificate of insurance, commercial liability with affidavit to state facts on support to prosecute and file a claim under strict liability no later than June 10 of the year 2021 is on the record. And with this, we're going to leave you. It's obviously that you haven't speak to Dr. Gatlin. Well, you watched the video, Cindy Mercer, and Dr. Gatlin was explaining about the Constitution, and Dr. Gatlin does not have the ability to make a report because he didn't speak the language for the Honorable J. Jesús-Arriaga and is now on the record. If you have a doctor that came to see your kid but did not speak the language, would it be fair that he can give him a fair treatment? Well, it's on the record. Now, for a doctor who claims to be a psychologist and does not know how to correctly tell this court of record and this Superior Court of Record the correct definition of the word, you're self-disqualified, doctor. And I wonder you haven't talked to this court because you cannot talk to the court. What are you going to tell the court? I went over and I did my evaluation with one glitch. I do not speak the language. And here, we're going to read it again for the record. Sir, this is the statement you made on the video taken on May 3rd of the year 2021. When the Honorable and for the Honorable J. Jesús-Arriaga Abonce requested for the language to be Nahuatl at minute 38.46 of Dr. Gatlin clearly said, I am not sure I understand what that is. Final answer, doctor? You didn't understand what that was, what that is, right? To understand is a verb. Doctor did not perceive the intended meaning of the words a language or a speaker. He didn't understand a word that was spoken by the Honorable J. Jesús-Arriaga Abonce. Interpret or view something in a particular way. Look for minute 39-37, the doctor acknowledgement, by saying, okay, I think we are wasting our time. And yes, you are wasting your time, but on the process you are damaging for the Honorable J. Jesús-Arriaga Abonce. Let the record show that today, on June 7, after past 1 month, and let me see, 4 days, the doctor has not rendered a report. And with that, I'm going to leave you for now, but we're going to start on another video. I had to make this video in a short notice, and I had to make it in this regard, in the regard that it was mentioned to this lower court, the supermarket court today. And the facts are forensic evidence on the record. It is so ordered. Now we will continue. And thank you very much for your attention. Cindy M. Mercer, you are here once more charged with violation of the First Amendment, and the Second, and the Third, and the Fourth, and the Fifth, and the Sixth, and the Seventh, and the Eighth, and the Ninth, and the 11th, and the 13th, and the 14th, and the 15th, to say a few. It's on the record.